From June the 1st this year, the Tenant Fees Act 2019 will become law. The law applies to all assured short-hold tenancies, tenancies of student accommodation and licences to occupy housing in the private rented sector in England. So if you're a landlord of a property in England, this is likely to apply to you. In this video blog, I'm going to brief you on everything that you need to know when it applies and the changes that you and your agent will have to make in order to comply. You are only permitted to ask the tenant to pay the following: the rent, a refundable tenancy deposit, a refundable holding deposit, default fees, charges for changes to the tenancy, charges for early termination, and then council tax, utility bills, communication bills. So let's look at these in more detail. You should agree the amount of rent to be paid with the tenant when agreeing to let the property to them. The rent should be paid at regular specified intervals, and you must not charge more at the start of the tenancy compared to a later period. For example, you cannot require the tenant to pay £2,500 in month 1 and then £2,000 in month 2 onwards. There's an important change here. The deposit is now capped at no more than 5 weeks' rent, where the total annual rent is below £50,000. It's still 6 weeks' rent, where the total annual rent is £50,000 or above. Any deposit you request must be protected in one of the 3 government-backed tenancy deposit schemes within 30 days of receipt. You must provide the tenant with information as to where and how their deposit is protected. And the deposit is their money, so you'll need to provide evidence to substantiate any deductions from the deposit at the end of the tenancy if challenged. Not a great deal has changed here. You can still ask for a deposit to demonstrate a commitment to rent the property whilst the referencing takes place. It cannot be more than 1 week's rent. You must refund the holding deposit where 1, the tenant later enters into the tenancy, 2, you the landlord decide not to rent the property, or 3, an agreement is not reached before the deadline for agreement, which is usually 15 days after the holding deposit is received. You can only retain the tenant's holding deposit if 1, they provide false or misleading information which reasonably affects your decision to let the property to them, 2, they fail a right to rent check, 3, they withdraw from the agreement, or 4, they fail to take all reasonable steps to enter into the agreement. You or your agent will need to set out in writing the reason for your decision to retain the deposit within 7 days of the deadline for agreement. You can still charge the tenant for late payment of rent once it's 14 days late, or lost keys, but it needs to be written into the tenancy agreement. We can charge up to £50 or reasonable costs if higher for work involved in amending the tenancy agreement. This doesn't apply to renewals. If a tenant requests to leave before the end of the tenancy, you're entitled to charge an early termination fee. This must not exceed the financial loss that you or your agent have suffered. And in these situations, we always seek to achieve an amicable solution by trying to secure a new tenant to take over. This minimises financial loss for both landlord and tenant, and hopefully it's common sense. Now, you'll be relieved to know that the tenants are still responsible for paying bills such as council tax, utility bills, broadband, TV, etc. That hasn't changed. The ban is being introduced in 2 stages. Firstly, all tenancies that commence on or after the 1st of June 2019 will need to comply with the new law. Secondly, from the 1st of June next year, 2020, the ban on fees will apply to all tenancies no matter when they commenced. Fees that might have been part of the tenancy agreement, such as renewal fees, will not be allowed. We never charge tenants for renewals anyway. The costs of referencing tenancy agreements, check-ins, check-outs, inventories, safety checks and deposit registration have up until now been shared by landlords and tenants. It was at the discretion of the lettings agent as to how they set and allocated these costs. Most agencies operated a fair and transparent policy, but this legislation has been necessary to stop tenants from being unfairly charged inflated fees. On balance, we at Anderson Rose support the ban. Integrity is central to how we operate, and it's been frustrating to be undercut by agents who could only offer low fees to landlords by overinflating fees to tenants. Now, as you know, we win business from the landlords, so it puts us on a more level playing field with the other agencies. Our policy has been to charge the tenant for referencing, the check-in, and a contribution towards the drafting of the tenancy agreement. As you will see from our website, this costs £372 including VAT. Meanwhile, we allocated the costs of inventory, checkout, deposit registration, tenancy agreement and anti-money laundering checks to the landlord and charged a total of £560 including VAT. We've looked at two possible options, either to scrap all additional move-in, move-out costs and absorb them into a higher all-inclusive commission, or to maintain our commission at the current level and work out a best value move-in, move-out bundle. We've decided that the all-inclusive option, while simple to understand, causes landlords of higher value property to pay more than they should when admin costs are pretty level across all property moves. It's the marketing costs that can vary. To treat our customers as we want to be treated ourselves is in our mission statement from when we launched in 2011. So to be true to that, we've decided to absorb more than 1/2 of the extra costs, and therefore our new move-in, move-out bundle will be £725 including VAT, and that takes care of everything. Rather than just lumping all this cost onto you, we want to stand shoulder to shoulder with our landlords and take some of the pain. We really welcome your thoughts and feedback on this, and I'm here to answer any questions that you have. As costs of moving have become cheaper for the tenant, we expect that rents will rise modestly and that will enable your net income to return to where it was. With the private rented sector experiencing so many legislative changes, it's so important that landlords are represented by qualified lettings professionals who can keep them informed and protected. The best way to know that you are is to check that your agent is a registered member of Arla Property Mark. You can log on to Arla's website and just type the agency's name into the agent search and you'll be able to establish. I hope you found that useful. If you are already looked after by Anderson Rose, the team and I thank you for your ongoing business and look forward to looking after you for many more years to come. If you're not yet with Anderson Rose, then please get in touch.